Hey, what's up, guys? Just wanted to share something with you real quick. If any of you guys are out there wanting to know more about and execute your right to travel, I suggest getting yourself a document such as this one, a legal notice that you can give to any law enforcement when you get pulled over. And this, because you got to understand, in your private capacity, you have the right to travel. It's when you're operating in your commercial capacity that you have to have a license. So if you're not operating in a commercial capacity, then they can't put a lien on your unalienable rights. They can't require you to have a license, and that's backed up by the Supreme Court and the Constitution. Just as this, what's written in blue here says, as it first starts out, if I choose, have the private right to engage in commerce, to either make a living and or as a common private right. However, at this time and at this very moment, I am not engaged in such activities, commerce. I have a private right to travel in pursuit of my goals, in pursuit of happiness, and to do so not for profit and for gain, and my private property to always be construed as private property, consumer household goods, exempt from congressional oversight and or regulation as defined under the Uniform Commercial Code, Article 9, 102 and 109 in law, and the courts have agreed and ruled that private citizens have a right to private travel without state permits and or license. So if you are an agent, a deputy, an officer, an official, an administrator, a member of the Department of Defense and or otherwise, the highlighted section in red below is for your special attention. If you disagree with any of the following, you are to provide proof of claim supporting your position backed by facts and conclusions of law and not presumption. If you disagree with any of the conditions stated herein, then I accept your offer under the following conditions, provided that you supply proof within 2 calendar days of receipt of this presentment as stated under the terms and conditions contained herein. So it talks about how passenger for hire means a passenger for whom consideration is contributed as a condition of carriage on the vessel, blah, blah, blah. So we're going to get into definitions, statement of purpose, and we're going to get into some Supreme Court opinions on the matter. Okay? So this is the part highlighted in red that the officer needs to pay special attention to, as mentioned before. You'll be inclined to tell me to take it up with the judge or other administrative officer. I am admonished to inform you that it has been taken up with several judges as mentioned above, and the supreme law of the land. So, if you wish to proceed in violating my rights, I conditionally accept your offer under the following terms and conditions. Should there be a disagreement, this is where your arbitration clause comes in. Should there be a disagreement as to my private right to travel, then all related parties, whether directly and or indirectly related, third party, interested party, and or otherwise, agree to settle any and all disputes by arbitration via the A1 Sales Arbitration Association, and if not available or otherwise be deemed incapable of conducting the proceedings either personally or through a subcontractor, the parties elect that the default arbitration shall be had through the Eon Foundation. And the parties agree that arbitrations shall be the sole and exclusive remedy for settling any and all disputes arising out of this agreement and or associated in any way with this agreement, as the affiant conditionally accepts your offer, but immediately upon rejection of this offer, you agree to walk away and leave me to pursue my travel goals unmolested. Should you interfere with my private rights in any contradiction of the aforegoing judicial determinations, which you are bound to adhere to, you will be held personally liable, as you waive any and all rights, immunities, defenses, and forever agreed to be astute concerning any matter and or issue arising hereout of and or related hereto. Should you be found guilty and or in breach of this agreement, and you agree to be liable respecting the fines and or penalties associated hereto at no less than $10,000 per breach, plus a penalty of $5,000 for each day of non-payment for each consecutive half-day of either breach or non-compliance. All parties agree that on any matter involving a default, that the arbitration may be solely through electronic communications held via de novo hearing. A party shall be granted 2 calendar days to opt out of this agreement to arbitrate. However, failure to provide evidence supported by facts and conclusions of law, contrary to the aforementioned stated facts, shall be construed as assent, consent, conduct, performance, which equates to tacit acquiescence with respects this agreement as a whole, and the party shall be bound herein and hereby thenceforth. Any challenge to this agreement as a whole shall be presented only to the arbitrator, who shall have the exclusive jurisdiction of making a determination on the issue. And this includes a severability challenge to the arbitration clause. I also attest that I'm a private citizen exercising my private rights as cognizable by the Uniform Commercial Code, Article 9, Section 102 and 109. All of my properties are private possessions, which include my rights, my physical and or intellectual properties, my name, as it is associated with my person. These rights are classified as consumer household goods and are exempt if you're operating off of a presumption. I must object, as presumption is not law, is not based on fact or conclusions of law. However, the aforementioned adjudicated rights based on fundamental facts and truths, I rest, stand, and rely on such, and do not choose to have my words spoken at any moment to be used against me, as I am not under oath, but I believe you are. Verification verification statement of attestation. I, Jason C. Joplin, have attained the age of the majority, and not a minor nor incompetent person as defined in statute, do hereby declare, as well as attest and affirm, that the aforementioned is wholly accurate, is based on actual first-hand knowledge and actual first-hand facts and conclusions of law, and presented on this day under penalty of divine retribution, if otherwise so help me God, who has witnessed this event in his notarial capacity. So if anybody wants a copy of this document, just hit me up, let me know. Everything is amendable. It is a Word document, so just hit me up. I could post a link in the description, but I'd rather just email it to you. So just hit me up in the comments, and I'll get this over to you. Or actually, they've been kind of blocking my comments, so just send it to my email at jasonjoplin2016@gmail.com. See, if I go over here to my videos, click on my videos, see on this "You Are a Bank" video, it says I got 1 comment, but when you open it up and you go to the comment section, see it says 1, but there's nothing there. So I can't see my comments, or at least not all of them, because I can see some of my comments. You know, if I go back to, you know, like this video right here, I think I can see
everybody
at least one of these comments. Let's just see. 2 comments. Yeah. See, I've seen those, but some comments they do not allow to go through, and it's like that with a lot of them. You know, like just like the bankruptcy of America. This has a comment on it.
They will cover.
But I think I've already checked this. But when you go into it, there's no comment. On these last 3 videos, I've got 2 of them that have comments, but I can't see them. So, and they're not showing up in my YouTube studio either as being held for review. See, I got that one, but I didn't get the other 2 relating this bankruptcy stuff. So anyways, just thought I would let y'all know that. So if you got anything to say, hit me up in the email, because YouTube is messing with me on my comments and on my views and all that kind of stuff. So anyways, I don't really care about all that, but I do want this information to get out there, because it could help some people. You know, there's people going through foreclosures and, you know, repossession of their vehicle, and, you know, the stuff that I've been showing lately is proof that you don't owe. If that's the case, the government has already paid. All loans are guaranteed by the government. All promissory notes, bills of exchange, bankers' acceptances, trade acceptances, drafts, those are all government obligations. So if you're going through some stuff, you know, there's a way out. You just have to present the right questions in court. So there's a way out. And you can do it. You can get out of that. That's my encouragement to y'all. Ignorance of the law is no excuse, which is why I had to go to the law to understand how money and finance works. I wanted to understand the financial systems of this world, the current financial systems of the world, how it operated, how banks operated. And now that I know, and I've seen the law, it makes perfect sense. Because I've always heard, well, for the last 10 years, I've heard that what the banks are doing is fraud on these loans, but I didn't understand why. Now I understand why, and I understand how to prove it. And it's really just a matter of going into the courts and putting it onto the record in a suit against these banks. It's easy to file a suit. You can file a suit as a pro se person, as one who has the power of an attorney over yourself. So all you have to do is learn the law, how to do it. That's what I've been studying for the last several years. I've been working on understanding the legal system, the court systems, and how to, in case I was ever involved in some sort of legal matter, that I wouldn't have to go to an attorney and be incompetent, that I could be competent enough to be able to handle myself in a court. It's just court. It's nothing to be afraid of. It's just court. It's all administrative. It's all administrative. Even criminal court is administrative. And it's pretty easy to prove that. And but the courts don't like that information getting out there. They want you to be afraid of them. They want you to get an attorney, because when you get an attorney, you waive all your rights. But whenever you exercise your power of attorney over yourself and represent yourself, I mean, how can you represent yourself? You're either, you can represent, the word represent is represent. How do you represent yourself? You're either present, you can't be represent, you're not representing yourself, you are yourself. You are the attorney, in fact. So, that all that stuff that I've been learning over the years about how court works and blah blah blah, what to do, it came in handy, because this past June I was served a summons, a legal notice, that there was a lawsuit against me for an accident that I had back in 2019 of December. And that accident, my insurance paid out on it. They fixed my vehicle, they fixed their vehicle, but then, the person that I hit, they didn't feel like that, they wanted depreciation of value for their vehicle. So they wanted more than just repairs to the vehicle. They wanted depreciation, so they sued me. And so I get the summons, and of course first of all, I can't afford an attorney, and second of all, I'm competent enough to handle it. So I drafted my own answer and filed it with the plaintiff's attorney and with the courts within the 30-day time period, so that I'm not in default. And then I started studying. Okay, I already knew how to do that part. I knew how to do an answer, and I knew the type of language to use because I had been studying it, but I didn't know the particulars. When the case, you can't know all of law. So after that, I started studying pertaining to my case, the law pertaining to my case. It's a civil matter. It's not criminal, and I found a remedy. And just the other day, as soon as I got the summons, before I even filed my answer, I contacted my insurance company, who I was covered with at the time of the incident, and contacted them and gave them the case number. And of course, I didn't speak to anybody. It was all answer machines. And so I left a message, and they said, in the message they said, we'll get back to you within 24 hours. We'll respond. Well, 24 hours went by, 48 hours went by, 72 hours went by, and I called them again because I'm fixing to have to file an answer soon. I got the summons and blah blah blah. Did you guys not pay out? Like, what's the deal? What's going on? Why are they suing me? So I didn't hear back until just the other day, last week, like Friday, and talked to the insurance. What's his title? He's the litigation adjuster, and so I basically found out that they fixed his vehicle. I didn't know. He had mentioned. Never mind. He had mentioned that they offered him an extra $800, and he rejected it. He rejected the offer. He wanted $3,000, and so I told him to make another offer, make another counter offer. He deserves something for his depreciation, whatever. So that's what the insurance company's fault. I was covered up to $25,000 in damage, but they just want to justify how much they're giving him, based on the make and model and how much it depreciated, blah, blah, blah. How much did he actually lose in value? So they're going to look at that, and then they're going to make another offer. And if they reject it, then we're going to move forward with a motion to dismiss. So I don't, because I'm not out to get one over on nobody. He wants extra, then he's entitled to damages. If his vehicle did depreciate, then he's entitled to compensation for that, along with the repairs. So that's why I want them to make this offer, because I had already come up with the plan to motion to dismiss, and then all of a sudden I get a call from them, and they're like, oh my goodness, this just came across my desk, and I see that you filed your answer already, and blah blah blah, and okay, that's okay, and so it started from there. And then I spoke to the attorney about it, to the progressive attorney that the case was handed down to. And he was like, yeah, your plan will work. It'll work. But at the same time, he needs to get compensated. They should make him another offer. And if he rejects that offer, then maybe we'll move for dismissal. That's the bottom line. Because they violated the civil rules of procedure by not serving me on time. And therefore, the case should not even proceed because it was done. They broke the rules. An action may only commence as the general rules of civil procedure. 15-3-30, subsection B. A civil suit may commence when a suit is filed with the court and then a summons is served upon the defendant as long as the summons is served within 120 days of the filing with the court. May an action commence. So technically it can get thrown out on a technicality and they get nothing. And it's after the statute of limitations, the 3-year statute of limitations of when they can come back. So they can't just turn around and refile. That's why they'll grant the motion. So, because we attempted to settle, they didn't want to settle, and therefore they're already in default. So the case shouldn't even go on from here. They don't want to settle. They want to extort, basically. So anyways, just thought I'd share that with y'all. Peace. Oh yeah, that arbitration clause, that's the teeth in your contract. That's what gives your contract teeth. Okay? Recourse. It's a contract. Courts are administrative. It is an agreement between two parties. So that's what gives your contract's teeth, is that arbitration clause. Default. If any party is in default, settled with arbitration. If there's any disagreement, settled with arbitration. So, because we have the right not to go to court. Arbitration is fully legal. So, that's your leg to stand on. Anyways, and that goes with all your contracts. You got a disagreement with someone you got a contract with, like your phone company or the electric company or anything like that, amend the terms and conditions of the contract. Send them notice that you're amending the terms and conditions. Add your arbitration clause. And when they default by not responding, then you can enforce that contract. You can enforce your disputes that way. Anyways, talk more about that later. Peace.